Well, welcome. My name is Ryan Nelson. I am an employment law defense attorney and an HR professional. I am responsible for Employers Counsel's Utah office. We have 6 attorneys, 4 senior HR, and we work with about 500-ish companies here in the state of Utah. Overall, about 4,000 amongst our 5 offices. And all we do every day is employment law and HR. Now, a little history. The medical cannabis. I was in Colorado back in 2012 and then in 2014 when the medicinal law passed and then the recreational law, which changed the balance with everything in Colorado. And I watched what happened with employers as they struggled to understand, what do we do with this? Because we have a workforce, we have drug testing, we have policies, we have expectations. How do we manage a workforce now that we have a legal cannabis situation, whether it's medicinal or even recreational? So with that in mind, and having worked with employers for a while, put together some ideas and things to consider in this presentation. We have about a little less than an hour, but we'll cover some of the key points of the law, and then from an HR and a legal perspective for you as employers, some thoughts to consider about what to do with or as medical cannabis begins to become more prevalent or perhaps visible in your workplaces. Because there are indeed about 7 different legal areas that medical cannabis will trigger or require you to think about simply by having the cannabis and a medical condition with your employees in the workplace. So we'll cover 3 of the big ones today, but just know that there are others that are out there and something to just be aware of. So the purpose of this class today, or this hour, is to give you an overview of the law, what happens, how it will work, what your employees will do, what their rights are, and then again we'll talk about the employment law and the HR issues in context of the cannabis. So I think it's helpful to first understand the timeline about how we got here. Now, I never would have thought that we would have a medicinal cannabis law in Utah. But having watched the process, how it developed, I think actually it's a good thing. And the way that Utah has designed it has safeguards both to allow for patient access, while at the same time creating a regulatory structure so we don't have a Colorado situation, which is the little green cross buildings everywhere you go with anyone who can purchase cannabis, as long as you at least look the age. So here's what happened. Here's how we got here. You had Proposition 2, which had enough signatures, landed on the ballot this year, and we voted on it. Now, eventually it passed, but there was a lot of political steps that happened before Election Day, which modified and impacted what actually Election Day meant. So the ballot proposition, and I'm curious, did any of you actually read the Proposition 2 language on the ballot?
I did.
You read the language on the ballot, but did you ever read the law that it proposed the legislature pass? You read it? Okay. Generally, there's like one person in every presentation that I've done. Many read the ballot proposition. Very, very, very few actually read the law that it was proposing the legislature pass. Interesting thought. Well, yes, understanding it yet. Yeah, it's a doozy, and it was just amended officially yesterday again. So Governor Herbert signed one of the bills that came out of the House this year, modifying some of the Medical Cannabis Act. So it will continue to change and evolve. That's one you want to watch each legislative session just to see what continues to change. So we had the ballot proposition. There were very, very divisive lines on this. Those who were in favor for patient access, because from a medicinal perspective, it can provide relief for a variety of different illnesses or symptoms. But then you also had opponents to it who said, yeah, that's just not us. We don't want this gateway into a recreational situation. Don't mind her. She's with the press. So look over here if you'd like. All right, then we go to Speaker Hughes. So Greg Hughes was the Speaker of the House, and having watched these divisive lines, read the proposition, understanding what the law was, or the proposed law, what it would do, he said, you know what, I think we have some areas where we can find some middle ground. and he convened a group of opponents and proponents for the medical cannabis. Sat them down literally in a room and said, let's talk about this. Let's see if there's a way we can work this out. They came up with what we call the compromise legislation. The compromise legislation is a version of it is what the legislature actually passed in the special session back in December. So with this compromise legislation, Governor Herbert said, looks like we have enough consensus. We can modify the terms of the Proposition 2 proposed law so that it satisfies a greater percentage of those who are interested for or against this measure. The special session then happened, Election Day. Proposition 2 passed. Now the irony and some political angst over this is Proposition 2 passed, but it didn't really mean anything because there was this compromised legislation hanging out there which Governor Herbert had said, we're going to call a special session. The legislature will be required to convene, and we will pass something, and it's going to look like this compromised version with some tweaks and adjustments. And it happened. The session happened on December 3rd. There was a supermajority that approved the compromised legislation. It hit Governor Herbert's desk that night, and the law went into effect on December 4th. So we are currently in a medical cannabis state. It is permissible. It is legal under certain terms and conditions, but it's here and it's happening now. Okay? Now, interestingly, right after the law goes into effect, there was a lawsuit filed in state court saying, yeah, this compromised legislative process was illegal. Now, I frankly, personally, disagree that the lawsuit has merit, but there it is. It's a lawsuit, and people can file that. I don't know where it stands currently. I haven't heard, but I don't think it goes anywhere. I think we continue to move forward as is without the concern that this compromised legislation was somehow unconstitutional because, frankly, the legislature has that authority and the prerogative to modify the language of a proposition. That's just what the Utah Constitution allows. Now, even more interestingly, and this is where there's a little bit of a challenge. For us as businesses, there is uncertainty surrounding the medical cannabis here in the state of Utah for a variety of reasons. Some of them employment law, some of them HR, some also because under federal law, cannabis is still illegal. Marijuana is a Schedule I illegal substance prohibited by federal law. And so you have a U.S. attorney in each state. That U.S. attorney has the ability to interpret and enforce federal law within the boundaries of the state. Now, the U.S. attorney for Utah has said basically this: I have great discretion about how I will enforce federal law here in the state of Utah. I don't yet have a formal position on what we will do with the state legalization of marijuana, but it is nonetheless still federally illegal. So there's some uncertainty there. Federal law could still enforce it here in the state of Utah, but we don't know what that will look like. My personal opinion is nothing's going to change. It will be permissible under state law as long as it meets the requirements, and the federal agencies aren't going to do much about it. There are in the nation 33 states that have a medicinal cannabis law on their books. I think the time for some patchwork of enforcement across the state network within the U.S. is gone. I don't think it's going to happen. Go ahead.
How many have a recreational?
10 by last count. And I suspect, and you will see, that that number will continue to increase. Now, what I think eventually happens long term, maybe 5 years, is cannabis is removed off of the Schedule I illegal substance and it's no longer illegal under federal law, which then resolves all of the various states and their patchwork of legislation to create a state version of legal medicinal cannabis or recreational. All right, so the HR menu is these three topics. These are the big ones that happen. We'll cover these at the latter half of the class, but what I first want to help you see and understand is what the framework of the medical cannabis law here in Utah looks like, and then how it will impact you as a business owner or as a business from these particular areas. And if you have questions, please speak up. Did you get the picture before I moved it? Okay. So if you have questions about it or in a particular topic of this that you want to discuss, please let me know and we'll cover it. All right, so the Cannabis Act creates well, let me back up. It is a statute, so it's a law. And within the law, last count, it's about 240 pages long. And it amends a variety of existing law, but also creates new Utah law. And as part of the new law, it creates a list of medical conditions that an individual must have, at least one of them, in order to consume the medical cannabis. Okay, so I must have one of these medical issues or conditions in order to be eligible to purchase, transport, and consume medical cannabis. Now, for those of you who were in the session this morning where we talked about other employment laws, this list is a list of disabilities under the Americans with Disabilities Act, under the Utah Anti-Discrimination Act, and serious health conditions under the Family Medical Leave Act. So any employee who has one of these conditions and is using medical cannabis, if you become aware of that as the employer, you now have these other medical issues or these other laws that protect medical situations in the workplace. You now have to deal with those. And how you interact with your employees, the things that you do, the standards that you impose or require, will be modified or affected by this. And that's really the purpose of the class today, is to help raise awareness so that you start asking the right questions and looking at these things, getting the expertise and the support that you need. In an hour, I can't answer every minute situation that may happen, but we'll cover again some general situations and examples so you can start to get a flavor for how this will affect you. Please, go ahead.
Pain lasting beyond 2 weeks.
Yeah, that's an interesting one, isn't it? So that's pain that is chronic, if you will, with which conventional medication will not treat or will not help. But it excludes opioids out of that. So if I have a condition and the opioids aren't working for it, that's not a qualifying condition. It has to be, I'm not taking opioids for it.
And what is the compassionate use?
Great question, great question. So if my condition is not on this statutory list that the legislature created, the individual with the condition, can go before a compassionate use board, which is appointed by the executive director of, I forget the agency within the state. Well, they're appointed and then confirmed by the Senate. I go before this committee, this board, and I basically tell them what I have, what my condition is. It might be rare, it might be, again, not on the list, but under the condition or under the circumstances and the condition, how it affects me, they have the ability to grant a waiver, if you will, as a compassionate use. Okay. But that decision lies with them. And the appeals process, how that works, we don't know yet. These regulations, the instructions haven't been created yet, so we're not sure what that really looks like. But there are, again, some mechanisms to help individuals who have a condition that's not on the list, but yet should, from a compassionate perspective, qualify for the medical use. Okay? Good question. All right. So, when we talk about the FMLA, actually, do you want to hear a little bit more about the structure of the Cannabis Act before we go into the HR stuff? Yes, in the back.
So is the cannabis and the THC, whatever else, I have an employee that gets hurt on the job.
Uh-huh.
And one of the company requirements is that he will take a pee test. Thus, that's how we determine, okay, this is, we're high.
Post-accident drug screen, yes.
How in the heavens is that going to work in the state of Utah now?
Great question.
As an employer, what?
I want you to hold that, and we'll use that as the example to talk through what you can do and what that looks like. Now, there are some uncertainties that I don't know, and we'll cover those too as best we can in the time. So the structure is this. So you have, again, medical cannabis. Cannabis does have THC. The law creates a regulatory process from growth to purchase, where it is tracked literally with a barcode system, so that any point along the way, the cannabis can be tracked, determine where it's at, where the end user is, who has it, but also there's a laboratory process where the quantity of THC will be tested. It can't exceed a certain amount. There are distribution points that will be created. Now, we call those distribution points pharmacies, which is a misnomer. Medical cannabis is not a pharmaceutical. It is not a prescription. It is a doctor-recommended treatment for some ailment that an individual has that was on that list. But it is not a prescription. It's not a pharmaceutical. You will hear that. Oh, I have a prescription for medical cannabis. I have a card that says I'm a prescription-carrying medical cannabis card holder. No, that's incorrect. The card or the cannabis is simply a recommendation from a physician who says or thinks that the cannabis will alleviate symptoms of a condition that you have. But there's no guarantee. It's not a pharmaceutical. Yes?
So can they just buy it from whoever?
Great question. How do we purchase the cannabis? So again, there will be distribution points. We call those pharmacies. There are two types. You have the state pharmacy, which is literally a mail order pharmacy. So if I live in a remote area of the state, I can send in my request to the state pharmacy, the state distribution center, and they will fill the recommendation. They will fill it and send it out to the local health department where the individual lives. I then go into the health department and I can pick up my medicinal cannabis. That's one way. Other points will be literally you walk into a distribution point where there will be a pharmacist, again, a misnomer, it's not a pharmaceutical, but there will be a pharmacist there who can talk with the individual about dosage, talk about frequency, quantity, stuff like that, and to help them work through the process of consuming the cannabis. Okay?
The same controls they had on opioids that came falling out of control?
I would
As
s-
an employer, I'm concerned about it, because I've got, we run 25 people.
Sure.
Just had a guy that just committed suicide last week on an overdose. I've got another guy that's on methadone because of an opioid problem. Now, I don't think I'm the only one in this room or in this conference down here that has an employee that has a problem because they have a pain clinic that is prescribing this. This is just another problem for us to try to have.
You know, you raise some interesting points, and frankly, one of the challenges will be as an employer, how do we navigate this? And how do we deal with individuals who perhaps abuse it, but have it lawfully and legally? How do we deal with that as an employer? So you raised some great questions. Let me address a couple thoughts first. From the perspective of the regulatory structure, in order to recommend the medical cannabis to a patient, to an individual, it has to be a doctor, a physician's assistant, or an RN, a registered nurse. Those are the three only types of individuals who can do that. Now, they have to go through a process with the state where they apply for the right, if you will, to recommend medical cannabis per the Utah Medical Cannabis Act. But they are doctors, they're physicians, they're RNs, they're PAs, the same as an individual who may recommend an opioid or prescribe an opioid. So to your point, is there a concern about abuse such as what we see with opioids? I think that's a valid concern. I don't have an answer as to how to address that. That's part of the challenge that we have in prescribing or recommending substances for people to take that have an addictive component to them. Now, is marijuana addictive, the THC? Yeah, I think it is. In the percentages that the law requires or permits, I don't know. That I don't know. And I think each of us are probably going to be different in how a percentage of THC, a limited percentage, will affect my ability to do something. But therein lies a very valid question, and I don't have an answer for that. It's a policy question that the state we have to grapple with. Great point. All right, so you have this regulatory structure, this framework, okay? Now, I, as the employee, I must have first the medical cannabis card. How I get that hasn't been created yet. We don't have the regulatory structure. But let's assume that it has, and I have the card. I guess that it'll probably look like a driver's license. It'll have a photo ID, barcode identification on the back, be scanned by the police officer, have some information that will be unique to me, but will allow me to purchase the cannabis when I go into a distribution point. I have to have that card in order to do that. Now, once I have the card, I then have to meet with the medical professional, the doctor, the RN, or the physician's assistant, who is authorized to recommend the cannabis. I meet with them. We have a doctor-patient relationship. I talk about the condition that I have, whatever that is, and if the medical provider agrees that it will assist me or alleviate symptoms of the condition I have, then I will be issued a recommendation to purchase the cannabis in a quantity prescribed by the law or allowed by the law. All right, now, here's where, you know what, in fact, let's take a detour from these slides, and I want to focus on your question because I think it's a very valid point. I'm your employee. I have the cannabis card. I have a medical condition. And give me a position that concerns you at your job about someone who has cannabis in their system. Give me a job title.
You're a plumber, you're standing on a ladder.
All right, I'm on a ladder. I'm a plumber. I'm just a regular plumber. Physical positions, driving a vehicle. I am working in tight locations or safety-sensitive locations, doing work that requires alertness, attentiveness, free from impairment, which is an amorphous term. But I have these obligations, these essential components to my job. Okay? You're my employer. You have a business to run with an incentive to avoid liability and death or injury to an individual or others because lawsuits suck and you don't want that. Okay? So here's where we have some questions and here's where this could go. Go ahead, Jared. Absolutely. I mean, OSHA does require.
I kind of want to take that to that next step. Let's make this the reality.
Okay?
You have to make sure that you're safe and go home at night.
Correct.
We're dead.
Correct. All right. So, I am the employee. There is no guidance in the law, in the Utah Medical Cannabis Act, that says what an employer can or cannot do for private employers. There's no guidance in terms of what you can or cannot do. So the assumption that we're starting with is status quo. Keep moving forward the same as you would before. Now, I will disagree slightly with that and add, you need to consider where you want to draw the line, where you care, and then design your policies around where you care and why. So we'll use again the safety position, the plumber, the driver, all of those functions. And to your point, Jared, yeah, we have an obligation to keep people safe. All right? So I'm using it, and let me give you an example of a scenario. All right, I'm your employee. You have a drug test. You described a post-accident scenario. I'm involved in an accident. You have a drug testing policy which says post-accident we test, and then based on the test results, we do something. It could be second chance, it could be termination, it could be discipline, it could be nothing at all. It just depends on what the outcome is. All right, well, I refuse to take your drug test and I tell you, inform you, I have a medical cannabis card. I don't want to take your drug test. Alternatively, what if I ask you, hey, I have a medical cannabis card and I ask you for some time off? Or I ask you to transfer me to a different position because I don't feel like I can operate the equipment or drive the vehicle safely. Real life scenarios here. All right, so in the drug test scenario, and I'm assuming that you have a valid drug testing process, that you have a policy that you consistently and regularly enforce. Okay? So your employee tests positive or refuses the test. What does your policy say happens in those situations with a positive drug test?
Go to a clinic.
Pardon?
They can go to a clinic.
What does that mean, go to a clinic?
Instead of in-house testing, then we can take it
It's a validation.
a validation.
Okay, so you have a lab test it.
Right.
Okay, so it's a verification of the test. And what happens if it comes back positive at that point? What does your policy say? Okay, termination.
You could be, we want you to go to this rehab, if you're willing to work with the employee, we want to see you get help.
Okay.
And we're going to watch this closer, we're going to monitor, we're going to do random drug tests.
All right.
Period.
So here's where there's some complication. You have a valid drug test process. The employee tests positive. You do have a lab confirmed, which we recommend Don't just use the rapid screen and rely on that. Have the rapid screen confirmed by a laboratory test. Okay, they check molecular levels of the substance, and that's the one that you can rely on in litigation or in other liability situations. So have the lab confirm the results. Comes back THC positive. Your policy says we terminate. Can you do that still? Yes, you can. However, under Utah law, the Utah Anti-Discrimination Act says that if an individual has a disability, even though they may be currently using an illegal substance like marijuana, if they have a disability, there is an obligation to accommodate that. Now, what is an accommodation? Well, it depends on the circumstances. Does it mean I have to throw the safety concerns away? No, but it means I need to find a way to allow the person to do their job with the disability condition that they have. So going back to the point I made about where you want to draw the line, within your organizations, you need to carefully consider when and why do I care about medical cannabis. If it's a plumber because of driving, safety, ladder, those types of issues, then you have a legitimate reason, safety, to be concerned about the influence something or the influence that an individual may be under when they're at work. So if you have those legitimate reasons and you've designed your test around those reasons and the individual tests positive, you're in a position where you can successfully pursue the outcome, whatever that is, termination, second chance, rehabilitation, whatever. Where there's a disconnect is if you don't have that legitimate safety concern. Say a receptionist, for example. What if the receptionist has a medical condition and she or he is using the cannabis, but you test and they test positive? Do you care in those types of circumstances that the individual has cannabis in their system? Maybe, maybe not. Maybe there's not a safety issue there or a legitimate reason for you to care in that situation. That's what I mean by carefully identifying the when you care, why you care, and designing your policies around that. Did you have a question?
Well, yeah, if I understand this correctly, though, there's really, like with alcohol, there's a blood alcohol level.
Correct.
Where's the line on marijuana?
Great question. There's not a line.
So how do you know if they're impaired or not?
That's a great point. So in designing your policy, you're not looking at impairment. You're looking at any measurable amount in their system. If there's a measurable amount, that will generally trigger a positive test. And so you design, if this is what you want to do, you design your policy around measurable amounts or detectable amounts in the system. The question is not whether they're impaired. The question is, do they have something in their system which we, the employer, determine we don't want because of a legitimate reason, safety, for example, as a concern. And you design your policy around that. But that is a valid question, and frankly, the other side of the argument. Well, what if I've consumed cannabis 3 weeks ago? I'm not currently under the influence. I'm not currently impaired. Can I still test positive? Yeah. So is impairment really the measurement we want? No, it's not. Because you can't measure impairment with cannabis. We don't have a bright line 0.08 standard, so to speak, like we do with alcohol.
So it's either got to be a black and white. If it's in the system, we don't accept it. It's not black.
You can choose to do that, yes. Alternatively, there are some testing labs who are implementing testing regimens where we can measure over time the THC percentage within an individual's body to see if there is abuse or fluctuation. So you set a baseline and then you can measure over time to see how that individual and their consumption of medical cannabis is affecting the percentages of THC in their body. So you could design a policy that does that and then work very closely with your testing lab to measure that. No, go ahead.
So as an owner, what's the limit?
It's how they handle the,
I mean, it
There's not.
can't be a floater.
Well, there's not an established level of illegal, legal, impaired, not impaired. There's not. And this is frankly, this is one of the frustrating things we have about this, because the statute, the Cannabis Act, does not say, employers, you have the ability to continue to do what you were doing before. You have the ability to test. You have the ability you're not required to accommodate the use of cannabis in the workplace. It doesn't say any of that. So that's what creates a lot of these questions and concerns, and frankly, some of the answers we just don't have. Go ahead and then in your comment. Federal's different. If you have DOT-regulated positions, or you are a federal contractor by virtue of federal contracts that you have with the government, your standards are much easier. DOT drivers, for example, we don't care what the state law says. If you test positive for THC as a DOT-regulated driver or in a DOT-regulated industry, that's not a justification for the positive test. You have tested positive, and federal law says there's a consequence and the employer can enforce that. So for your big vehicle drivers, the DOT regulated, this is a much, much easier question. If they test positive and they say, well, I have medical cannabis and I'm taking it, your response is, sorry, that's a violation of our policy and the consequence is whatever. Your question.
Well, that was one of my questions, if federal government supersedes state regulations, but
In that instance, DOT and federal contracts, yes.
the other question is that if you have an employee that tests positive and you fire him and he has a medical card, can he come back and sue you?
Great question. Let me give you an example. There was a case in Colorado, and this was a medicinal cannabis case. Now, the law in Colorado said, when they passed, creating the right to have medicinal cannabis, the law said, employers, you're not required to accommodate the use of medical cannabis in the workplace. Notwithstanding that language, there was a company, Dish Network, this was a big case, they had an employee who was consuming medical cannabis and had been for a while. He was a model employee. He used it at night to sleep so that he could come to work the next day. And he worked and did great. The company implemented a drug testing process. He was tested positive, and was terminated. He filed a lawsuit and said, hey, wrongful termination. I have a right to utilize legal medical cannabis under a couple various points of state law. Now, I bring that up as an example where I think we will be headed here. I think the same question applies for us. We don't have that language in the statute that says, employer, you don't have to do this, or you can continue to do that. So there's some uncertainty, which I think will breed litigation. As these questions, an employee perhaps is terminated for possessing the cannabis card and losing his or her job because they had a measurable amount in their system, and they say, you know what, that's not right. I'm filing a lawsuit. It's a wrongful termination or some other claim. I anticipate those will happen, and that will force the courts and perhaps the legislature to respond with some clarity, which in my opinion, we don't currently have.
So it could be that, like we mentioned, that, you're up on a ladder, you're driving a vehicle, and, you got a person impaired, then you'll be forced to say, okay, well, come in the office and sit in the chair for a while.
So that moves into what I would characterize as an accommodation under state ADA law. And to be clear, you are required to accommodate a disability even if the person is using medical cannabis to alleviate symptoms of the disability. Okay?
Is it legal to ask the person before you hire if he has a card?
We don't have a clear answer, but I would recommend that you don't ask that. I would recommend that you focus on what are the essential functions you're hiring for. Can you operate a vehicle safely? Can you operate or climb a ladder safely? Can you get down into a trench safely? Whatever those functions are, that's the focus of your interview. Because if you ask, do you have a medical cannabis card? And they say yes, well, now you know that they have some kind of condition. Now, you don't know what that condition is, but the only way you get the card is if you have a medical issue. And so now potentially you've created a disability discrimination complaint because you've used a medical condition as the basis to withhold employment or to terminate employment.
Can do a pre-employment drug test.
Correct.
And then go.
Correct. So if in the pre-employment drug test, and let's set this up, I have a list of applicants, and I've reviewed them. I have my top 3. I send the top 3 to a drug test as a precondition or a qualification to be eligible for employment. And if all 3 of them blow hot on a positive, test positive on the drug test, technically they are now disqualified from employment if that is your standard. So you can do that. Now, what happened in Colorado is this. Companies struggled to find employees who could pass the drug test and be clean of THC in their system. So employers in Colorado were being confronted with the choice again of when do I care and why. Now let me give you another example. You have an employee currently working, and we don't know that he or she has a medical condition. We don't know anything about what's going on, but we observe behavior that suggests the individual is under the influence of something. It could be alcohol, it could be cannabis, it could be an opioid. We don't know, we don't care. But we have this standard where we observe, and if we see behavior that is concerning, that triggers our ability, per our drug testing policy, to submit the individual to a test. Can we still do that? Yes. And if the test comes back positive, the question is not, are they impaired, so to speak? The question is, we observed behavior that was concerning from a safety perspective or from a productivity or efficiency perspective, and that triggered the test. The test then yielded a positive for something, let's say it's THC. Do we have the legal right to still terminate or discipline under those circumstances? Yes.
So when it's administered, do they tell you do not operate heavy equipment? Don't drive? I mean, some of the pain medication you get, your doctor says you can't X, Y, Z. Does that come with those kind of conditions?
I don't know. I don't know in the patient-doctor relationship if the doctor will be advising or recommending what you said. You shouldn't operate heavy machinery or drive based on the dosage and the frequency of the medical cannabis that I am recommending you take. I don't know. Now, if we, as the employer, though, have a concern based on observation, again, I smell it, I observe behavior that suggests some kind of unsafe behavior or impaired behavior. Can I test? Yeah. Can I have a conversation with the employee? Perhaps. Can I ask for medical support to justify what they're telling me? Yes. As long as I have a legitimate business reason to trigger some of these questions, asking those questions or requiring the employee to provide medical support is okay. Both the ADA federal and the state version allow for that if there's a legitimate reason underlying the request. Safety concern. I observed behavior that was unsafe. And so it led to a conversation, and during that conversation the employee says, yeah, I have a medical cannabis card, I'm taking medical cannabis. Okay, time out, hit the brakes. Now we need to have a conversation about your ability to do your job safely, because safety is an essential function of your position. So what this does is just creates an additional step or hurdle, depending on how you want to look at it, in this conversation and relationship with your employees when you have a legitimate reason to be concerned about it. Again, safety is an easy one to look at, to justify these extra questions or these extra steps. All right, what other questions do you have?
In our safety policy, it states that we can do a drug test anytime we want.
Okay.
Random drug test.
So you have a random policy.
Now, if we find out somebody, and we don't know he's got a card, find out somebody is, test positive, and then they show us the card.
What do you do?
What do you do?
Okay. This is again where there's some uncertainty, because the law doesn't say one way or the other what happens next. You have existing law which says, the Utah drug testing statute says, I, the employer, if I follow these requirements that the law says, I can test, and as long as I follow certain requirements, if the employee tests positive, I can take a disciplinary action, even up to a termination, and I have protections from liability. Now that statute still is enforced. There's no changes to that. So I think in your example, yeah, I can still do that. I can still test and take an outcome, a disciplinary outcome. If the employee shows me the card, does that change anything? No, not really. But again, the best position for you as an employer to be in is, well, we test because we have that legitimate reason to test. Safety, efficiency, production requirements. If you're in manufacturing, perhaps it's the ability to operate a machine safely or at capacity or at a certain amount. Those are all legitimate reasons which would undergird and support your drug testing policy, such that when the employee comes to you and says, yeah, I've got this card, excuse my drug test, you can say, well, no, because we have these legitimate business reasons which we've designed our policy around, we don't care that you have the card. The concern is safety or efficiency or whatever that is. And I think you are in a better position to defend should a claim happen in those instances.
Well, they sign their policy, and if they sign that policy and if they don't indicate that they have a card, doesn't that make them somewhat liable?
Well, let me answer that question with an analogy. In some drug testing policies, and our recommendation is, if you want, you can include language that says, if you are prescribed something by your doctor that may impair or prevent you from safely performing the functions of your position, you are under an obligation to talk to your doctor and verify that you can indeed do your job safely. So I think that same language can be used and simply just extended to cover medicinal cannabis, where you impose an obligation on the employee to verify with their provider, again, who is a doctor, an RN, or a PA, to ask those questions and find out. And I would even go so far as to provide or require the employee to provide the job description to the doctor.
That's what I was going to say. You better be specific on your questioning.
Correct. Now, can we do that? Yes, you can. You have that flexibility to do that. But again, the gray area, the uncertainty, the cloudy aspects of this is, well, how do we, there's so many nuances. How do we handle all of these different situations? Well, I don't have an answer for that because there are questions that we just don't know. So as for now, I would say recommendation is you can continue to do what you do. Test when you test. Accountability standards for whatever they are, discipline, second chance, termination, whatever, you can continue to do that. What I recommend you begin to do and think about, though, is should we narrowly tailor those policies based on the functions performed? Instead of blanket policies that cover everyone and everything all the time, perhaps there are some subsets of our population that we don't care about. Maybe they don't have a safety concern. Maybe they don't have a performance component. So should we test in those instances? Maybe, maybe not. I think there's a valid reason why you would not, just out of concern for where this may go. All right, what time is it? Can you tell me what time it is? 10 till. All right, so we've got a couple minutes, and then I've got to reboot for the next one. So what questions do you have? Has this been helpful at all? Or do you leave with more questions? Well, you always leave with more questions. That means we did a good job. Yes?
Does this conflict with this morning's session? So I now have to make accommodations. I have to obey this FEMLA law, and I got to obey. Am I going to get conflicts with those?
So his question is, I have a disability, an individual with a medical condition who has the rights to possess, consume, and transport cannabis under the Utah medical cannabis law. Now, though, there's this disability, the medical, the ADA, and then we also have the Family Medical Leave Act. How do I navigate all three of these? Well, the question is, you put them all on a table and you have to look at all of them at the same time and figure out what each law requires and make a decision. So it's an answer without giving you an answer. It depends.
I don't want to be the first one to challenge it.
Well, no, you need, this is where unfortunately operating a business just became more difficult. You need expert assistance to navigate these. And that's where defense attorneys, employment law attorneys, HR consultants, this is where they come in. This is where you rely heavily on them. Because navigating these 3 laws, they're all high stakes. They all require that you do certain things. And you have to look at a situation from that global perspective and then carefully figure out where you go.
Well, and also it's concerning because you said this is like an evolving law that is continually changing. But yet I don't feel like we're like getting these daily bulletins of what's changed.
Certainly not.
You know, so are we gonna be notified when something changes that would affect a small business or a business owner?
How the legislature won't do that. The legislature isn't going to blast out, hey, we passed an amendment to the Cannabis Act, you're all on notice, read lines 1,000 to 1,500 for more details. No, that they're not going to do that. So you need to rely on organizations and associations. The UPHCA is one. Ours, it's what we do. We push out content that helps employers understand what we do with this. So as the law changes, we push out a legislative update next month that talks about all the employment-related things. So yeah, there are organizations that do that.
That as an employer, we are gonna be responsible to educate ourselves.
Correct.
Otherwise, we're responsible.
Correct.
For whatever happens.
And that's
Yeah.
in a way kind of unfair, but that's what it means to own a business and operate a business. Yes.
How does current law, like say somebody's smoking marijuana or whatever, has a living system, we get in an accident, how does the police look at that and say they were under the influence?
Great question.
And how does that fall back on us if we have an employee out there with a medical card that's supposedly okay to use it, he gets in an accident in one of our vehicles, what does our insurance company say? What does the police say?
There's a lot of questions within that one question. First, I would be communicating with my insurance company and asking the question about, if I have medicinal cannabis users who have the card, what is your position regarding their ability to be insured? Yes or no? If the answer is no, then you now automatically can disqualify an individual who has medical cannabis from driving one of your vehicles because you can't get insurance on them. And the ability to be insured is an essential function of the position. So that eliminates perhaps some of the question. If your insurance company says, yeah, we'll still insure, and that individual gets in an accident, and the officers do a field sobriety test, or a blood test, or a draw at the hospital and determine that there is THC in the system, how is that going to look for you? Well, it could suggest that the accident was the result of an impaired driver. And if I'm driving a company vehicle impaired, that's company liability. So therein again lies a question: how do we design a policy, a process, or expectations to protect us as an organization, to keep our drivers safe, keep people safe, and avoid liability? Could you limit or eliminate the ability of a medical cannabis card holder from driving your vehicles out of concern for safety? Yeah, I think you could. And could that be a legitimately defensible decision? I think it could.
I think it eliminated every employee that has a card, because if you have an employee with a card and he is working with another person and something happens and that other employee gets injured or gets killed, you're in big trouble.
So this is again, and I'll end on this point, this is where you need, from this point forward, to stop and identify where indeed you really care, and then identify why. Why? Why is it that I'm concerned that this individual working next to this individual may have medical cannabis in their system? And you need to develop those policies to support, or develop the reasoning to support the policy that you will then implement. Because if you're challenged, that's your defense, is we have a legitimate reason. Safety, again, that's the easy one. Safety. And in this situation, this individual can't have some impairment or limited ability to do the job because of these reasons. Therefore, we've created this requirement to eliminate the risk. It's a tough situation.
It is.
Again, this is what we do. Let me, if you want, here's my email address. If you're interested in learning a little bit more, it's not up there. Oh yeah, there it is. If you're interested in learning a little bit more, send me an email. Be happy to tell you a little bit more where we're headed with this. All right?
One thing we've been able to do is anybody that's driving a company truck, we have them go down and get a DOT medical card to drive. You can request a 7-panel, 9-panel drug test. You can determine right there whether or not you feel safe about letting them have it. And they expire every year. So you gotta go down every year to get a medical card. Your big truck drivers have to have that same medical card for their CDL license. Anything over 10,000 GVW, you drive a 1-ton truck, you really should have a medical card to even drive that company truck.
So that's a great
So that's a
point.
good way to kind of determine.
No, that's a great suggestion, because again, why do we care? 10,000-pound truck barreling down the road, there's a safety issue, there's liability, there's all sorts of death and injury that could potentially occur. So we have a legitimate reason to regulate that. We have a reason to care. And so in those instances, here's what we do. You could still go even one step further and require tests, drug tests, for anyone who drives a vehicle. But that's a great example of, again, narrowly defining what you will do under certain circumstances based on the size or the weight of the vehicle. Great point. Thank you. I'm glad you added that. All right. Last minute questions?
Yes. I understand Denver area is kind of a big issue with all this planning.
Yeah. It's tough because it's recreational. I can consume it like I would alcohol. And again, keep in mind, when I consume cannabis, it can stay within the tissues for a month. Even though I've not used it for a month, I could still trigger a positive test. So yeah, employers in Colorado are struggling in some instances to find employees. I anticipate the same thing will happen, probably in a lesser extent, but will happen here. Which again forces an employer to ask the question, when do we care, when do we don't?
And the HCG thing doesn't have any.
No, THC is still present in medical cannabis. THC is one of the molecules of cannabis, and it does have an impairment, if you will, an addictive component to it. But again, medical cannabis percentages have been limited, or the law has been designed to limit the THC percentages, but it's still in medical cannabis. It's a THC derivative. CBD oil. So CBD oil is a whole other question. CBD oil can have cannabis in it, or THC, excuse me, and it may not. It may have other stuff. There's some that's been tested to have fentanyl in it. So CBD oil is a derivative of cannabis plant. It's a different version of the cannabis molecule, but it doesn't generally, in its pure form, have THC. But can it have it? Yeah, it can. It just depends on what you're getting and where you buy it. So I could be taking CBD oil, which is legal, but still trigger a positive drug test because there is some THC, there's something else in there that would trigger a positive test. I was working with a testing lab a couple of weeks ago, and they said they had a result come up where a woman, 50-year-old lady, tested positive for cocaine. And she was astounded. He went, "What do you mean? I don't know what it looks like, what it is." Well, come to find out, she was taking CBD oil, which had cocaine in it. And so she was taking the CBD oil topically, or however it was being taken, and it triggered a positive test for something else.
Did you feel real good though?
I'm not sure how she felt. All right. Hopefully this was helpful. Lots of questions, I get it.